I'm the president and CEO of the Montpelier Foundation. As stewards of James Madison's lifelong home, we share the story of Madison's preparatory work for the Constitutional Convention that resulted in the outline of our national charter, his authorship of the Bill of Rights, his 4 terms in the US Congress, and his service as Secretary of State and President. I'm delighted to be kicking off the Constitutional Toolkit series on James Madison's 270th birthday, as he was born March 16th, 1751. I'm also happy to announce that today marks the beginning of the Constitution Initiative at Montpelier, a comprehensive decade of programming that will be devoted to the Constitution, contemporary challenges, and historical origins. Ranging from student programs to all-day workshops, artist talks, and week-long symposia, the Constitution Initiative each year will bring together a historian in residence, an artist in residence, and both will drive contemporary conversations to engage experts, students of all ages, and many others invested in interpreting and understanding the Constitution. In addition, it will help guide our conversations, programs, interpretation, and tours both virtually and on site. This is the culmination of a year's worth of efforts by a robust cross-departmental team. A huge thank you to all of the staff and board who have been involved in the Constitution Initiative. This initiative will broaden our reach, deepen our voice, and create a national presence for our programs, our whole history, and our partnerships. And speaking of partnerships, it's truly been our pleasure to partner with the Center for Civic Education and their president, Christopher Riano, to plan the Constitutional Toolkit series. This 6-year series was inspired by you. We've gathered your frequently asked questions about the impact of the Constitution has on everyone, every day, in almost all of our interactions as Americans. There's a lot of confusion and misconceptions about the Constitution, what it says, what it does or doesn't do, and what it allows you to do. We look forward to addressing your questions over the next 6 weeks. Before I formally introduce Christopher, we want these programs to be as engaging and relevant as they can be for you. As questions occur to you, in your controls at the bottom of the Zoom window, click Chat. The chat window will open on the right side of your screen, then simply type in your question and hit enter, and our colleague Emily Voss will be helping to field those questions from the chat as the evening continues. Tonight's topic, rights and liberties. Tonight's topic is rights and liberties. Our guest speaker, Christopher Riano, is the president of the Center for Civic Education, the nation's largest constitutional law and civic education nonprofit, dedicated to promoting an enlightened and responsible citizenry, both in America and around the globe. Riano also lectures in constitutional law and government at Columbia University, where he teaches comparative jurisprudence, constitutional theory, and the fundamentals of government. He has served as a speaker and author at dozens of conferences and in a number of publications on numerous parts of constitutional theory. This, very exciting, his book, Marriage Equality, From Outlaws to In-Laws, which he co-authored with Professor William N. Eskridge, Jr. of Yale Law School, tells the definitive story of the marriage equality movement from 1967 to 2015. Last week, the book was listed as a finalist for the 2021 American Bar Association Silver Gavel Award. So congratulations, Christopher. Christopher has served as the assistant counsel to the governor of New York for education, arts, and constitutional law. He has also been the general counsel for the New York State Liquor Authority and administrative law judge for New York State, as well as a partner at Droin Lee LLP. And as well, he is the founder and CEO of the Riano Group, LLC. So please take a moment to welcome Christopher. We're thrilled to have him here, and I'm thrilled to consider him a colleague and a friend. Christopher, to you.
Roy, thank you so much. That was a really generous introduction. And I have to say, the fact that I'm able today to kick off on your founder's birthday and to really help lead what I think is, and I know will be, a long-term, collaboration on a number of fronts is so exciting. And I'm so very thrilled to be here with everybody tonight. I think one of the things that makes me so excited specifically about the Constitutional Toolkit series is that as much attention as we focus in America on the importance, and the very important importance, of K through 12 education, professional development, and Emily at Montpelier knows this very well. There are so many members of our society that I constantly think about, how are we reaching? How are we looking at a civic and constitutional education from cradle through career? And I think that's a really important thing to be considering, because unlike any other topic, unlike math, unlike science, topics that I very much celebrate myself as a former engineering student, every single classroom is a civics classroom. Every single workplace is a civics workplace. Every single experience we have in our society relates back to civics and back to constitutional theory. And I think that's something to be considerate of when we think about the importance of the Constitution in our daily lives. And in particular tonight, when I really want to have a robust discussion, please feel free to send questions. One of the things that they force you to do as a constitutional law professor is to think on your feet and answer the hard ones. So I am very open to discussion around our topic for the evening, discussion that surrounds things even somewhat tangential, because when we talk about rights and liberties, when we talk about the jurisprudence and what the law is, and how does this impact our daily lives all the time, I think that it's incredible to take a really large perspective, to zoom out, and to show and see how truly impactful rights and liberties are, how important the background of what they are means on a daily basis, and even more specifically, the Constitution is an incredible document. And I think as Americans, it's important that we celebrate and understand many of its strengths. I also think it's important for us to understand and celebrate its weaknesses and its nuances, and understand that it's a continual dialogue. And we have the opportunity in every day of our lives to be interactive members of our civil and civic society, and to make a difference when it comes to honoring both the legacy of those strengths, but also improving upon the weaknesses that we see on a daily basis. And it's one of the reasons why I'm so excited to be able to be involved in this space. And with that, I am going to share my screen. But as I noted, please definitely do ask questions as I'm talking and sharing my screen, because I want to make sure to make this interactive, and I will try to watch with Emily as everything bubbles along. And with that, let me pull up, and hopefully everybody can see this. And let me just these are the beauties of Zoom, as we all know. And what we're doing today is really kicking off this 6-week series. And I'm excited to kick it off talking about rights and liberties, because at the very heart of so much of the Constitution and what we think about when it comes to the Constitution is something that we've heard so many people, whether it's our students, it's our family, or it's our friends, say at some point or another, I have this right, I have this liberty, I can do X, or you can't do Y. And I always find that so fascinating when I have those conversations with students, when I have those conversations more generally, because I think the reality is that this is so much more nuanced, so much more complicated than that. And that's really where I want to center our conversation this evening. And when we think about the Constitution, we think about it on a big national level. And this is kind of the big picture of what we're doing this next 6 weeks. But the Constitution really does have that everyday impact. And between cable news and social media and comments that I know we've all heard from friends and family, there's a lot of confusion and I think sometimes misconceptions about the Constitution and what it says and what it does, even maybe more importantly, what it doesn't do. And this is something that we want to address in a dynamic dialogue starting this evening and going on for the next 6 weeks. And I think hopefully the guests that Montpelier and the center are able to bring together can really address some of the most pressing questions that folks have. And again, with lots of time saved, and I'm certainly going to save lots of time today for questions and discussion on what's important to you about what we've talked about. And just a little bit of background, as noted, I am the president of the Center for Civic Education. I've been on faculty at Columbia for 10 years. I'm very excited about my first book that just came out. And I'm very excited that it seems to be getting a lot of positive reviews. And previous to this, I was the Governor's Counsel for Constitutional Law, Education, and Arts here in New York. And I've worked for a state agency, and before that I was a partner at a law firm. And very proudly, I did go to law school in Virginia. So I'm very happy tonight to have a chance to zoom back to the state where I did begin my legal journey. And this is what, in a general sense, I want to cover today. These are kind of the three big buckets that I want to look at. And I want to look at one of the most fascinating topics I think that there is, which is to delve into what is the law. And that's a really hard question. And it's something that I think is critical when we're exploring the centrality that rights and liberties really form in our society. I want to make sure that we can understand how this relates to current rights and liberty theory. I think that's really important to begin to unpack how this has a daily impact. And then I want to look at modern rights practice, and particularly how this works in reality, considering the conflict that exists in many of the rights and liberties that people frequently will discuss. And in fact, a book came out today that I want to talk about a little bit and have some discussion on that I think helps to explore some of what I mean when I say modern rights practice and modern rights conflict. But I want to start with this. We are truly living in an incredible constitutional time. There are many, many points in our history as Americans where we have faced unique constitutional challenges, unique challenges in the way in which government and the people have interacted, the way in which the government has interacted with itself. And in the 230 plus year history of at least the current Constitution, I think that there are other times that have been incredible, but I want to be very conscious of the fact that this moment in time is an incredible constitutional time. And the goal here is to give folks nonpartisan tools to understand these ideas generally. And the idea, again, is to talk about difficult topics and to have questions and discussion around some of those difficult topics, because we are in such an incredible constitutional time. And I emphasize to everybody one thing in particular as we kick off. And then I'm going to actually ask a question that I hope people can help answer in the chat in just a second. So get prepared. It's a benefit of being a professor. We ask a lot of questions at the same time. So when we're looking at the law, and we're looking at what is the law in relationship to rights and liberties, I want us to be very focused on thinking about the big picture. It's not difficult at all, whether as an attorney or scholar or teacher or student or somebody who's just interested in current events or other parts of the way in which society operates. But as a civic member of our society, as a member of our civil discourse, it's important when we talk about big constitutional topics, I think, to be thinking about the macro level, thinking about the big picture. And so I emphasize that at the get-go, because I want folks to think big picture when it comes to understanding how this works in our society. And with that, I definitely want to open this up to some answers in the chat. What do people think about when they think about what is a right or what is a liberty? I'll even expand it. And this is the best part about constitutional law. There are no wrong answers, so you cannot get this wrong. But I'm really curious to hear people's thoughts, because I think this will help inform our discussion. What do people think of when we say rights or liberties? What are some of the first words that come to folks' minds? because I think this word and the word right, the word liberty, have an incredible history in our society. And I'm curious to know, what are some of the first things that people think of? And Emily, I see, has put this into the chat, and I appreciate that, to make sure that folks, and Pat McKenzie, I like that. Life, liberty, pursuit of happiness, right? The incredible trifecta that comes from the way in which the Declaration looks at some of the core values that we have. Oh, natural rights. So glad to see things like that. Natural rights, because we're going to talk about natural rights and questions of freedom of speech. The First Amendment is central to our American identity, and we're going to talk about that today. Something that can't be taken away by the government. Yes, you're absolutely right. There's most certainly that concept when it comes to thinking about rights and liberties. This is incredible. These questions and these answers are right on point. God-given rights and freedoms. I like that, because there's definitely a natural right inclination and natural law inclination when it comes to understanding the law. Absolutely. And liberty, that's an incredible, incredible word. I'm so glad to hear people use that word. There's a very American identity that's wrapped up in the word liberty. And I think that that's something that we'll explore somewhat this evening. And Sharon, thank you about the question of equality. You know, in so many ways, and one of the things I want to think about when it comes to talking about what is a right and what is the law, which is what we'll talk about in a little bit. And negative rights, no question that negative rights feature here too, is the nuances that exist when we talk about some of these things. And the fact that we use big words like liberty, right? And Sandy, you just used it, I'm so glad. Or equality, or justice, or morality. Those big words have a lot of history attached, a lot of meaning attached. And I think it's critical that we recognize that as we go into an understanding of what is a right and what is the law, because those big, big words can have a lot of different connotations. They can have a lot of different historical aspects, and they can have a lot of different realism and realistic aspects as we unpack really how this works in the real world. And I put this up. I found this today as I was looking at this, and I thought this was probably one of the easier definitions that I could find for what is a right. I'm certainly not advocating that this is a perfect definition. And it's from the Stanford Encyclopedia of Philosophy. But in many ways, I think that it encapsulates a lot, because it discusses how rights are entitlements to perform certain actions, or entitlements to not perform certain actions. I'm so glad to see so many folks talking about both positive rights and then negative liberties. There's, of course, the entitlement to be in a certain state or not in a certain state, entitlements that you can perform certain actions or not have to perform certain actions. And in many ways, they do dominate a huge amount of our modern understanding of what justice looks like and what is permissible when it comes to our social fabric, and which institutions in our social fabric are just or equal. And rights and liberties, really as a structural work and entity, form government. They form the content of law, and they shape morality as so many people see it today. And when we accept a set of rights, or we accept a particular liberty, we are approving that distribution of freedom and authority. And I really liked that phrase. That's what really jumped out when I was looking for something small to look at here. And I think that's something that I want to make sure that we keep in mind, is that when we accept a particular right or a particular liberty, we really are distributing freedom, and we're distributing authority by accepting that. And I think that becomes really important when we look at the history of how this all comes together more generally. And these are not all of the definitions again, but I want to give as broad of an overview to guide our conversation tonight as possible. Because there's positive rights, again, the ability to do something, negative rights, the ability to not do something, and sometimes things that we don't always think about when it comes to rights and liberties. The idea that there are individual rights versus group rights. think that's something to be very conscious of, especially when it comes to modern human rights and modern natural rights theory. And there are questions that surround natural rights, rights that are just given to us as the fact that we are human and on this planet, for lack of a better way to put it. And then rights that we give ourselves through law or through creation of law or something along those lines. And it's why I think it's important to always be conscious of how rights, liberties, and the law are so incredibly intertwined. And it's difficult to divorce them in any real way because they operate together in so many different fashions when it comes to the Constitution and it comes to understanding constitutionalism and a broader scale constitutional theory. And so I want to open this up to questions again, because I think by answering these two main big questions, we really will have a good base on how to discuss rights, liberties, and the law. And so I want to ask everybody, what is the law? And I want people to, again, to zoom out, think broadly, and in the chat, when you have a second, what exactly is the law? And again, I emphasize a broad macro level view of how the law functions or what the law is critical when it comes to understanding rights and liberties. So if anybody has a guess, everybody was absolutely on point before. So clearly we have a really, really robust group here that understands all things. What is the law? And the power of government to protect rights. There's no question, Kemp. Government forms and the law forms a baseline of our interactions, right? What the law is, at least in some respects, is the social contract. That's absolutely right. It's the things that we put into place in a system of rules. I think that's very important. Fundamentally, law helps to define our relationships with one another. We are in many ways guided by those that definition of our relationships. Constitutions are certainly law. There's no question there. And Sean, I like what you said. Agreed upon rules and frameworks. That's a good one. That's hard. And I think that's important to note that as we think about the public good, absolutely, and the management and regulation of rights and liberties, and the system of rules and what Congress passes, this is all absolutely correct. And the reason that I want to emphasize that early on is because that broad view of what the law is will help us really come to an understanding tradition, culture. That I'm so glad to see that early, because the law absolutely has a lot to do with tradition and a lot to do with culture. And I think in so many ways, it's critical to have an understanding of this, because the law probably is a little bit larger picture scale, like everybody's just put into the chat, than we might think from the outset. And what do I mean when I say that? And what do I mean when I say that it might be a little bit more broad? Well, in so many ways, excuse me, I don't know what. I apologize for that. This is part of the fun that happens as we are working in Zoom, and here we go. So when it comes to looking at what is the law, I want to think in three different buckets. And I want to think of these three buckets as working together, not necessarily working separately. And I think we'll see why in just a moment. Now, from the outset, if we think about, and people mention natural law, natural rights, right? The idea that there's a freedom of all according to a universal law, inborn and an inborn right that belongs to every man in virtue of his humanity. Immanuel Kant had a huge influence on the founders. He had a huge influence on constitutional theory. I once had a student actually write a paper that he called the Constitution after Kant's influence on how the Constitution looks. And there are definitely natural rights philosophy that is baked into the way the Constitution looks. So I want us to keep that in mind, because that forms a piece of the puzzle. But by definition, it can't just be a natural rights philosophy or natural law philosophy when it comes to understanding the law or rights or liberties, because we've done something as people when it comes to rights and law. We've written things down, or we've created standards and concepts positively, as many noted in the chat, whether it's through legislative action or historically through the executive action that existed from kings and queens. We've created positive law. So when it comes to humans and our ability to produce law, there's something there too. The Constitution is a positive document. It's the creation of a fundamental theory of government and a fundamental theory of rights and liberties. So that absolutely forms a basis as well for what the law is. But I also think it's important to note the law can't just be something universal that exists everywhere. The law can't just be what we create and write down, because we wouldn't then need courts and we wouldn't need judges. And I think this is what helps pull the theory together, what the law is, again, in a very zoomed out fashion, because courts absolutely have an influence on the law. We're all well aware that two different judges might look at a speeding ticket in two different ways, and that formulates the law at that moment, right? There's lots of instances where legal realism, i.e. the reality of how the law plays out and works, has a direct impact on rights and liberties. And yet, I don't think you can separate that in total from what the law is. I think if you look broadly and generally, it's all of these things in working together often. And that's where I want us to focus some of our rights and liberties discussion this evening, because I think that will really help frame out how this operates on a larger scale. So for example, let's go all the way back to Magna Carta. Magna Carta 1215. And I want to go to Clause 39 in particular, because Clause 39 of Magna Carta is still good law in the United Kingdom. And it is in many ways the fundamental concept of due process and due process of law in the United Kingdom. And it talks about, in this agreement that happened literally 806, I think, years ago. I went to law school because I'm not good at math, but I think that might be right. In this fundamental agreement between the king and other members of the gentry at that time, when it came to looking at rights, laws, and realism. And why do I want to use those three as a lens to understand this early United Kingdom constitution and constitutional document in the United Kingdom? Because the fundamental idea that no free man shall be seized or imprisoned or stripped of his rights except by the lawful judgment of his equals, is that a natural right? Well, it might be. It's something that we see in law before that at times. We see it after that at times. We'll talk about that, no question here tonight. Did it matter whether it was written down positively and created in this document and agreed to? Well, it might have mattered. It might matter. It might be important that in order to secure this right, to secure this liberty, that it's written down positively, that people agree in a document or in some other unwritten fashion that this is the law? Or does it not matter at all? Is it a realism question? Is it about how people look at this in the bigger scheme of things? Does it, if the king actually abides by this? And there's no question that there have been times where the king has not, since this became a clause in Magna Carta. Those are the broader questions that I want to be thinking about as we really dig into some of these pieces of law and some of these pieces of how rights and liberties come together. And note, this very much has an impact on exactly what we would look at in our own system. This is the Fifth Amendment. This is a part of our Constitution. No person shall be deprived of life, liberty, or property without due process of law. This is an imported idea from Magna Carta. Magna Carta had a very large influence on the way in which Madison and others thought about the Constitution. But is it a natural right? Is it existent because as humans we believe it's important to have procedure? Is it a positive law? Did it not exist before it was written down? Or is it really a focus on something like where we need to be focused on realism, because at the end of the day, it only matters if it actually comes into effect by a judge or a jury or others that have the power to bring it into effect. No different than the 14th Amendment. And that's why I want us to think about these rights and liberties in this broad perspective. The 14th Amendment sounds amazing. No state or nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This will remind us and come back to a question that surrounds the big words that we hear in rights and liberties, right? The idea of justice and morality and equality. But are these natural rights? Did they exist whether we write them down or not? Do they only exist because we put them on this piece of paper? Or do they only exist if we enforce them in a realistic fashion? And that's why I want to use the legal lens to look at rights and liberties. And that's why when we're in the great balancing act in a constitutional democracy like the United States, and a constitutional republic, and a democratic republic like the United States, we have to constantly be thinking about how rights, liberties, and the law are balancing one of the most difficult questions that exists in constitutional theory, which is the issues that are inherent in majority rule and the issues that are inherent in majority rule that protects minority rights, and the fact that majority minority are constantly in flux, and the fact that that is a much more fluid situation, particularly when you do not have a pure democracy necessarily, and you have a constitutional republic. And so this is something I want us to be thinking of as we are looking at rights and liberties, because this is one of the fundamental questions that is attempted to be answered in the Constitution. It's not answered completely. It's never going to necessarily be answered completely, but it does form the basis of the theory of what was attempted over 230 years ago and has been attempted, frankly, ever since. And that's where I want to take us when we think about how this relates to current rights and liberty ideas. And again, emphasizing as broadly as I can to keep thinking about the big picture. It's very easy to point and look at one particular instance and question its constitutional relevance. And I'm not saying to not do that. In fact, I hope that after this evening, everybody has a toolkit that they can use to question individual situations. But by thinking big picture, we can see a system. And I think it's the system and having the system in a large sense that allows us to answer the day-to-day questions that come up in our civic lives. And we can look at Madison. And Madison, when he was thinking about rights and liberties, was the one who really put together the Bill of Rights. And something that I always find fascinating is, as much as we attach to the First Amendment was not first. In fact, after he introduced the Bill of Rights in June, I think by September, there were 17 that were left after some debate in the House. And after that, there were 12 after some debate in the Senate. And I've kind of condensed this a little bit. But only 10 were ratified by the states by December of 1791. And in fact, one was ratified and was the last amendment ratified in the early 1990s, and one was never ratified. And the original proposal for the Bill of Rights is starkly different than what we see today. It was actually, in many ways, a larger revision of the Constitution itself. Madison originally thought of ways he could weave the Bill of Rights into the Constitution, or pieces of the Bill of Rights into the Constitution. And that was rejected and instead was appended the way that we think of it. And I think that's important to note, because I think that helps inform our current understanding of why the Bill of Rights specifically looks the way that it does. And I always come to the First Amendment, again, not because it's first, but because this is the one that I hear about most often, aside from maybe the 5th or 14th. Because of the way I think it's written, and because it enshrines what many people will call our 5 major freedoms in the United States, and because so much comes up under questions that arise because of the First Amendment, because it gets to the very heart of some very American concepts of rights and liberties regarding religion and speech and press and our ability to assemble and to petition for a redress of grievances and things like the press. The press is the only constitutionally protected private industry. It's amazing to think about that when you look at the Constitution as a whole and the right that that affords the press and the liberty that that affords the press as the only constitutionally protected private industry. We've all had a student or a friend or a family member talk about the importance of free speech and how incredible that right is, vis-a-vis how speech laws look in many other parts of the world. And there's always been questions about what it means to respect the establishment of religion and to ensure the right of the people to peaceably assemble. And I want to emphasize this when we look at the First Amendment in particular. It says Congress shall make no law. Obviously, that's changed over time because of the 14th Amendment. And what's known as incorporation of the various different amendments. But the way in which this amendment has been interpreted over time has changed significantly. And we'll talk about that a little bit later. And it's why modern rights theory and modern rights conflict can become very complex. And it's why I want us to think about this from the legal system that I outlined and what the law is that I outlined to help us understand better why these words have such attachment and power in our current society. But I can't just leave that at the First Amendment. This is the Fifth Amendment, and I know everybody here is probably well aware of what's known as Miranda v. Arizona, which was a legal realism case. It was a legal realism case because the Supreme Court found that by looking at the text here, and the text specifically that says that nobody shall be compelled in any criminal case to be a witness against himself, that you have a right to remain silent when it comes to the police. And I want us to use this as a great example of why those legal theories tie together, because there's this inherent idea that there might be this natural ability to make sure that you shouldn't be forced to testify against yourself. And that includes before you may have even been accused of something. But the text here doesn't say you have the right to remain silent. It says you have the right to not be compelled in a criminal case to be a witness against yourself. So I want to be mindful of the legal realism that's read into that and the legal realism that exists that has been read into that text, because I think it gives us a better perspective on what the right and liberty actually is. No different than the Sixth Amendment. So the Sixth Amendment, and until Gideon v. Wainwright wasn't read this way, but after that, it was read to give an incredible amount of rights and liberties, but in particular, when it comes to have the assistance of counsel for one's defense, it doesn't say that you have a right to pick your lawyer. It doesn't say that you have a right to have somebody appointed and paid for by the taxpayer. It doesn't even necessarily say that you have just a right to counsel specifically and what that means to have the right to counsel specifically. It's something that harkens back to natural rights and what the natural rights should be in a particular matter. It also is something that obviously was positively created. But again, when it comes to realism, this has been read into this text. The reality has been read into what it means to have competent counsel, what it means to have counsel appointed for you when it comes to criminal law. And so I want to be mindful of that when it comes to the right. The right is something that comes from all areas of legal theory and all areas of the background that are baked into our understanding of the American Constitution. And that's where we end up with something that's known broadly as a Miranda warning. And I found one of the old ones that I used to have actually in a case, and the idea that you have the right to remain silent, that anything that you say can and will be used against you in a court of law. That's not written in the Constitution specifically necessarily. Those words themselves are not necessarily found there. And You have the right to talk to a lawyer and have them present while you're being questioned. You have the right to assistance of counsel, maybe. What does that mean? How does that fit into a natural rights perspective? And if you can't afford a lawyer, one's going to be appointed to represent you. That's, again, something that's read in from a realism perspective that harkens back to what are the natural rights that we believe our members of our society should have, as informed by the text of the Constitution and as informed by the realism of the modern day. And the idea that there has to be a waiver, this is not written in the text. And so is a Miranda warning a natural right? Is it a codification of a constitutional right? Is it an understanding of, I'm going to use this term, democratic norm, i.e. unwritten constitutional norms that are informed by constitutional text and natural rights that we believe exist? And that's the big place that I want us to think about when it comes to rights and liberties. Because I think in so many ways, it's very easy to say, I have the right to bear arms. And I think it's much more complicated to think through, well, what does that mean from a broader constitutional perspective? And how does that fit into our constitutional toolkit that we carry around when it comes to our civic lives every day? And I think this is best shown in some ways by the fact that there's text in the Constitution that you could ask the vast majority of constitutional scholars what it means, and many of us would say, I don't necessarily know. And this is the Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. One of my favorite professional development opportunities I've ever had was a day that I got to work on teaching the Ninth Amendment alongside a number of federal judges. And before we walked out to teach this large group of incredible instructors, I looked around and at my co-presenters and said, half jokingly, I'm well aware that none of us necessarily understand the Ninth Amendment. And I think we should go out there and talk about what we know, but also admit that we don't necessarily know everything that's enumerated here and encapsulated here. And we all looked at each other and then had a good laugh, because that is something that's debatable. There's a lot of debate about what this might mean and historically what this has meant, and whether this encapsulates natural rights. Does this instead look at the democratic norms and the unwritten constitutional norms that exist and the unwritten rights and liberties? Or is it just a way that Madison was looking to ensure that everything that's written in the text is not everything that we understand? For example, the right to privacy, which has been read into the Ninth Amendment in certain instances and in certain ways, but of course is not necessarily directly in this text. And I think this takes us to where I want to spend a little bit of time, but then make sure that we turn into an opportunity to address questions and comments. Because modern rights practice and modern rights conflict and how this works in reality, I think is very informative when it comes to a better understanding of this larger picture perspective. And why do I say that? Well, Jamal Green today, quite literally today, published this book. I have not read the book. I am intending and looking forward to reading the book because it's being talked about. He's on faculty at Columbia Law School. And what I think he says, and I'm quoting this from the kind of tear sheet on the book, and I found this fascinating when I saw this come out, that he very much delineates that there's a right to remain silent and then a right to free speech. There's a right to worship and a right to not worship. And you can be free from discrimination, but then you have a right to be quite hateful. And you have a right to life, but then maybe a right to own a gun. You know, rights and liberties are a sacred part of our American identity, but the way that they are seen today, and it's why I wanted to have our third part of the evening on this, is actually as a source of some of our incredible divisions, as opposed to our incredible opportunities to come together. And most importantly, I think one thing that's happened, especially more recently, is when it comes to complex issues that arise under rights and liberties, we've turned in many ways to judges and asked judges to often make our rights and liberties battle one another and imagine and find ways to possibly see if rights and liberties can coexist or not. which does in many ways, and I like this language, reduce law and reduce rights and liberties to somebody who wins and somebody who loses. And I think that is distorting of our law. And I think that's why I wanted to make sure that we covered some of this when we think very broadly about how this operates today and why it is more complex and difficult than to just say, I have a right to do X. Because our rights and our liberties can have impacts on other people. And I think it's John Stuart Mill that really explores in many ways how that can operate from a philosophical standpoint. But it's important to think about that balance and how my right or my liberty may impact somebody else's right and their liberty. And that it's not necessarily always a zero-sum game. And it's through that view that it is possible to maintain a system that ensures majority rule and yet protects the minority rights as we think about minority rights and minority liberties. And when we think about rights-based conflict, I always want to be conscious of where it's best to adjudicate these conflicts. And I know I just mentioned the courts, and I think that's because in many ways, over the years, we've often turned to the courts to adjudicate conflict when it comes to rights and liberties. But in part, the reason I find that so interesting is that the courts are, at least in the broader sense, the least democratic part of government. Courts don't necessarily have elections to pick judges, especially of course, at the federal level. And our legislatures, where we most likely think that it would be best to adjudicate some of these conflicts because they are the most democratic, generally speaking, bodies, don't have and have not recently been the places we adjudicate rights and liberty conflict. And the executive, it depends. And the executive at certain points seems to be involved in these things, and at other points doesn't get involved. And I want to think about that from the constitutional broadness that I know all of us can. Where should we think about how rights and liberties conflict gets decided? And does it have to always be a zero-sum game? And I think that's why I wanted to think about this conflict as the third part of this evening. And especially when it comes to the fact that when we're looking at the various branches of government, the legislature is the first branch of government. It is in Article 1. That was not something that Madison and others did without thinking very deeply about where they wanted the vast majority of authority to reside. And it certainly was not necessarily the courts. And I think that the courts serve an incredible role. But we have to think about the adjudication of these conflicts when it comes to understanding what our rights are and how we can express those rights and when and how best to express those rights and or those liberties, and knowing that those conflicts are going to arise. Let me use a current example. It's a case that I just worked on last summer, which is Fulton versus the city of Philadelphia. And in this case, there's a question about the government violating the First Amendment by conditioning an agency's ability to participate in the foster care system based on non-discrimination and non-discrimination rights and responsibilities. And why, let me broadly say this. In the bigger sense, Philadelphia passed a non-discrimination statute, and the Catholic Services and their foster role wants to exclude LGBTQ families from participating in their particular foster process. And so you have a conflict of rights, you have a conflict of liberties. How do we best resolve those? We have a First Amendment issue when it comes to religious freedom, and we have the complete understanding and importance of local statutory anti-discrimination legislation. And how do we balance that? And how do we balance that rights-based conflict? And I don't think it's as simple as saying one is a winner and one is not a winner. I think it's far more nuanced as we look at the broad scope and the broad picture of how the law operates over time, and religious rights and anti-discrimination rights. And thinking back to the theory of law, how does this plug into natural rights theory? Is there a natural right to have the religious freedom argument, or the natural right to be free from being discriminated against, especially when it's been positively passed by an elected local legislature and put into local statute? Is it just matter what the realism is on who's on the Supreme Court at the moment? I mean, those are the real world questions that I want us to be thinking about when we begin to analyze current rights conflict and current liberty conflict, because that's where the rubber in so many ways hits the road. And we take everything from theory into practice. There's the great Snyder case and the question of signs and people protesting at military funerals. And this was decided years ago, but I use this only because my students always just love this case. And the idea that you can pass a statute, and there was a statute passed in Maryland that prohibited protests at military funerals, and went up to the Supreme Court, and the Supreme Court under the First Amendment 8-1 said, you can't regulate speech that way, even if it's incredibly emotional, even if it's incredibly potentially offensive, even if it's potentially outrageous. How does that fit into our rights analysis? How do we balance the right of the individual to speak and or the right of the majority to elect a legislature that passes a statute? That's really important. And it can't just be as simple as First Amendment versus statutory interpretation. It's far more complex. It's not just the natural right, the positivism, it's the realism. It's the idea that the court, especially in recent years, has been very pro-free speech. And that realism really gets baked into that First Amendment and rights analysis. No different than the Tam case that came out, and the court here found that there really isn't a hate speech part of the First Amendment. And I always find this fascinating. People are always asking about hate speech. There's a lot of discussion about what's allowed under the First Amendment and what's not allowed under the First Amendment. But the unanimous Supreme Court said there is no hate speech carve out when it comes to the First Amendment. And there's a question that can be written about, well, then whose rights or liberties are being protected and whose rights and liberties are maybe not being protected? And is that a legal positivism issue because of Madison's drafting of the First Amendment? Or is it a legal realism issue of how the First Amendment's been interpreted over the years? And again, I don't necessarily think it's one or the other. I think it's all. And I think that's what gives us the tools to analyze what's happening in the world. There's the great case that came up when it comes to Apple and the FBI and issues about whether they can forcibly, the FBI can force Apple to unlock your phone. First Amendment issues. There were 13th Amendment issues, which were incredible. And again, I just want to give these examples as the questions that come up when it comes to these big picture questions of, do you have a natural right to privacy? Legal positivism, not so much in the Constitution, maybe some Fourth Amendment questions. But what about the realism? People do not like the government necessarily saying you can forcibly, and the government ordering somebody to forcibly open a phone. That's what I mean when it comes to these big picture questions. I'm curious, and I want to see if anybody in the chat can answer this, and I'm going to close in just a second. I'm curious if these quotes, and I picked these two quotes from one particular case, because I think this helps us understand this all a little bit more broadly. Does anybody know where the case that these two quotes comes from? And I think that will help really show this large picture. Is there anybody who knows where these two quotes come from? It is the same case. It's the exact same case. I think it helps tie this all together. And Katie, you are correct. It is Obergefell. This is the case where same-sex marriage became the law of the land. And the reason that I want to use these two quotes is because what this shows is this interplay between questions of the life, liberty, and property clause in the Fifth Amendment, the life, liberty, and property clause in the 14th Amendment, the equal protection clause in the 14th Amendment, and how, if we look at our American experience and we look at rights theory and liberty theory, we have baked in natural rights in so many ways to those words in our Constitution. Those words have an incredible and powerful meaning when it comes to legal realism and interpretation. And you can see that in the phrase above where we're talking about the Liberty Clause. We can see that in the phrase below when we're talking about the Equal Protection Clause. And I want us to be very conscious of the fact we can have a lot of debate and discussion about whether something's a natural law, a natural right, and human right. Lots of discussion. We can have a lot of discussion about the difference between a constitutional concept and a statutory concept. and a lot of discussion about how that operates and how the executive may be bound in different ways under either of those theories. But legal realism is critical to understand, and different judges, different justices, different individuals, different members of our society are constantly and continually interpreting all of these different words. We're constantly interacting in a civic manner to look at all of these concepts. And I think that is the beauty of rights and liberty theory. I think that's the beauty of actually our constitutional operation. And I'm certainly the first that says that there are a lot of weaknesses that can come from some of this. But I also argue there's a lot of strengths. And I think that's something that we should all be rather interested in constantly thinking about, because the strengths and weaknesses come down to our everyday engaging as civically virtuous and civically participatory parts of our American experiment. And again, I come back to these definitions because I think these definitions are very informative. I think seeing them again is very helpful. Rights dominate modern understandings of the actions that are permissible. They structure the form of governments, the content of laws, and they shape our morality and how we look at our morality. And they really are a distribution method of freedom and authority. Again, the ability to do things, the ability to not do things. Don't forget that rights and individual rights and group rights can be different. And I want to, that's something that we can be conscious of, especially when it comes to human rights. And again, let's think about the theory of law. I use this little example. This is an entire course that I teach. And so I try just this, and what is the law? I try very hard to pack it in as quickly as I could this evening, because I want to make sure to turn to questions now. But I assure you, in the last 10 years, I've come back to this many, many, many times. This has helped me understand why a decision looks the way it does at the Supreme Court, why an executive has acted the way that they have, why the legislature may be passing some bill or not passing another bill. This has been very helpful to understanding civics generally. And I think that looking at this in a broad sense will be helpful to everybody here when it comes to looking at rights and liberties generally. Again, I come back to this book. I'm not necessarily, although I'd be happy to promote Professor Green's book because he is a really great scholar. I just think that it's a very timely book, and it's talking about very complicated topics that hit right at home when it comes to this evening and what we're thinking about when it comes to the balancing of rights and liberties. And with that, I come down to a quote from James Madison. Knowledge will forever govern ignorance, and a people who mean to be their own governors and must arm themselves with the power which knowledge gives. I think that's a very, very powerful quote, because one of the things that's very unique about a democratic constitutional republic like we have is that we are entrusted with so much and so much involvement in our civic duty and our civic responsibility to be a part of that fabric. And so I think with knowledge and the ability to interpret what's happening around us, we're given an incredible opportunity to maybe bolster some of those weaknesses and make our society more equal and more just and more fair when it comes to looking at the balance between majority rule and minority rights. So with that, I'm going to stop screen sharing. I tried very hard to stick to an hour to open for questions.
I'm very impressed.
So I am like, I unfortunately, like I said, I could do this. That's an entire course, probably 2 courses. So I apologize that I packed so much in so quickly, but I think that it hopefully will be helpful, and I'm really excited to see what people have asked.
Yes, so I've had several questions that came through over the last hour, some of which you actually answered subsequently. So good job anticipating questions. But I do want to get back briefly to a question from Sean, actually. So Sean asks, do you think that breaking down the 2-party system in this country might help the legislative branch become more relevant or able to address some of these topics in a manner that the Supreme Court has really become the bigger voice over the last 50, 60 years?
There's no question in my mind that the Constitution was designed for the legislative branch to be the first branch. That is where the hard decisions are supposed to be made. Candidly speaking, the deals are supposed to be made. Discussions are supposed to happen. People are supposed to work in tandem wherever when they can, to come up with compromise. It's not a place where everybody's supposed to be happy with the result. It is certainly not a place that was ever anticipated or expected, but that's not always going to happen. And there are certain pieces of legislation historically that have passed, and I can think of the 14th Amendment. The 14th Amendment passed on a party line vote. So they think that shows an incredible amount of, and one of the most important amendments ever, of sometimes it's not going to be possible to find compromise. But I come back to this. I think in many ways what's surprising to me is that Congress, instead of realizing that through that compromise, debate, discussion, and dialogue can be the first and remain the first branch of government, said Congress has just somewhat allowed the executive and the court to fill in those gaps. And the court has written in decisions and said, in many cases, Congress, hey, feel free to pass something. We'd love for you to actually be the one that makes the decision. And the executive generally doesn't do that. But if Congress instead was passing legislation like it was designed and finding that compromise, I think the executive would find itself in a much more defensive, not defensive, but diminished position when it comes to its authority. I think one of the things that's been really interesting to see is that we're not rewarding our elected officials necessarily for that compromise, for that accomplishment. We're in some ways, in many cases, rewarding them for not compromising, not accomplishing. And most important of all, as I'm the first that would argue that the Constitution and Congress and the federal government are absolutely critical, one thing that I always come back to when I talk to folks in the field or students or teachers or anybody in the public is it shocks me how few people are aware of their local representatives and the local bodies of government and their state representatives and state bodies of government, because it is there where the vast majority of impact on your life will be found. The people that control the fire department, the people that control the sewers and the water department, the people that have general police power at the state level, that's where so much of government exists. And that's where interaction is possible, because most people are not calling up their state senator every day. Most people are not calling up their local representative, who they can usually actually get on the phone every day. And that's where so much happens. So I think even aside from the shift to the Supreme Court, there's been an even greater shift at time over the years now back to the states in so many ways because of federal inaction. And I'm not necessarily saying one thing is good or another. It's not that way when I think of it from a constitutional perspective. Instead, I think it's important to recognize those shifts and to make the decision as the electorate and those who are part of our American experiment, whether that's what we are thinking from a realistic perspective, we want the laws to look like, and we want the government to look like.
Thanks, great. That's a great answer. Okay, so I know that this question will also, I think, speak to you as a civic educator. So Mark asked a question. At one end, school students are basically taught that the First Amendment is important to the future of a democratic republic. However, there's also, particularly in popular culture, a frequency of instances where it feels like speech has been shut down. And so as a teacher, this person is noting that students sometimes feel like they're self-censoring because they don't necessarily want to go into the world of controversial topics because they don't want to be punished for it. So this person is asking for some suggestions as to how can we encourage students to talk about controversial issues in a way that feels like they can.
And I think that's such a wonderful question. And I very much understand what you are mentioning and thinking about. I was very fortunate at Columbia to be the chair of the committee that wrote the free speech and free expression rules at Columbia University in 2015. And one of the things that I've always found so fascinating about Columbia is we are definitely at least one of the, what I would call the big free speech universities. And as a student there, when I was there as an undergrad, every single day, there's a huge protest there today. There's a huge protest there yesterday. There's gonna be a huge protest tomorrow. Columbia is all about our protests. And it's something that I think we celebrate in our history, but it's also really interesting to think about what happens not just outside of the classroom and on campus, but really on in the classroom and on campus and or in a school building. And I think it's not always easy, because I myself, even at the graduate or college level, have very much had to encourage my students to ensure that there's a safe space to have discussion and productive dialogue. Because I think if there's any place that we have to be able to have that, it's in a class on constitutional law and constitutional theory. And I would say the same about civics. We're not necessarily talking about easy topics. That's not what we do in this field. And it's not that it's not important to think about the ways in which we can find broker compromise, but in so many ways in civics and a constitutional education, we're teaching people to have reasoned and rational discussion. We're teaching the importance of the tautology of learning that it's good to challenge one's thoughts. It's good to think through how other people have experienced the world. It's good to have that background and knowledge to inform our own understanding and thoughts and experiences. And that shift is not an easy shift. I'm the first that says that. It is actually quite difficult. But I do think it's important to be cognizant of that when it comes to teaching, because one of the things that I try very hard to do, and it's not easy, is I definitely get students from lots of different walks of life. I'm the first that would argue that as interesting as Columbia can be, I certainly get students from a lot of different backgrounds, and it's something that I always found very exciting. And I think as an educator, you're right. It's sometimes difficult when students don't want to speak up. And it's not always easy to foster that safe dialogue and debate and to keep it a safe dialogue and debate. But I do think it's important for the work that we get to do as educators, because I think it's important that as folks and individuals go into the world, they are able to have those skill sets. And I think those skill sets are some of the things that really come from the work that we do in civic education and constitutional education, and broadly when it comes to thinking about how we engage. And I think that's really important. So I think I'm the first that admits that it's difficult, and I'm the first that says that it can actually be one of the most difficult things we encounter in a classroom. But it's something that's always mindful. I'm always very mindful of that specifically, because, and I don't always, and I never put that expectation on a student, but I'm always very mindful of, is that something that I can help foster? Is there debate or discussion that's safe that I can help put together? And so it's just a constant thing that I've picked up on over the last 10 years and I have no doubt it's going to continue to be something that's constant going forward, because we're at a moment of incredible constitutional time, and we're asking and we're discussing difficult questions that aren't necessarily going to have simple answers.
Well, I'm not sure if this is a segue to easy questions or simple answers, but so early on, actually, when you were referencing the background of the Constitution, we were talking about Magna Carta and due process. I had a question early on about how we should understand the thought process of people who call themselves constitutional originalists, and what does that mean, and how are those views of the Constitution fundamentally different in modern constitutional thought?
I've always found that such a fascinating, and I know exactly what you mean. I know what people mean when they say that. And I've always found that such a fascinating, like heuristic, I guess, that people put themselves into those boxes. And here's why. If we had the option to talk longer, and I could show everybody the original public meaning of the 14th Amendment, the original public meaning of the Equal Protection Clause, the originalist argument that would come with the 14th Amendment and the Equal Protection Clause, it is wildly different than the current interpretation of the Equal Protection Clause. It is night and day different than the original public meaning and all of the language that surrounds the Equal Protection Clause, and where the Equal Protection Clause comes from in the Ohio State Constitution of 1851. And I will be the first that admits, when I did the research on this for my first book, I was blown away myself, because I said, there's no way that this was the original meaning, and this is where people are right now. And that's where we get to, that doesn't make any sense, because that's not the theory. And yet, I think that is very informative, because I think what that shows, and at least what I would most likely argue, is that while those are very nice things for people to say, the reality of what happens at the Supreme Court, or the reality of what happens in the legal world is so much more complicated than that. And justices come into every decision with much more nuanced opinions than what was Thomas Jefferson thinking in some particular day when he wrote a word. And while they may say that, I'm going to be candid, that's just not really a reality that we can center on. No different than how you can't just sit here and think, oh, what does this mean today? And we have to think about how this means exactly what it means today. And there's no other framework to look at, because I think it's all of those things. I think it's a view back to what are the core principles that we believe in as people in our society, as members and Americans in our society. How have we codified that in words? How have we codified that not in words? Because there's lots we have not codified in words. And then how do I take the facts that are in front of me and actually apply that to what I think we should get to? And there's a whole part of realism where you can think about, well, does a judge go into a case wanting to get to a certain point? Or does a judge go into a case not really sure and just thinking about how they get to that point? Or do they back from that point up into their theories? You can look at it in so many different angles from a realism perspective. But I think it's why I encourage zooming out, because I think it's so much more complicated and nuanced than just saying I'm an originalist. It's such an easy way out, no different than how it is to say it's a living document. No, we have something much more complex. And that's what makes it so incredible. But it's why I always say I like to take the broad perspective.
Okay, thank you. That was also really helpful. So this is not a question, but a comment, again, from a teacher. So it's a really useful teachable moment for students to understand how their use of particularly social media and what they perceive to be unlimited free speech rights on social media can have an effect on them later in life. So an observation from the teacher, but certainly something for all of us to be aware of, not just students.
Oh yeah, oh yeah. This is an incredible time for free speech. All of these really amazing questions that are brought up when it comes to social media, which is not the government, but does it start to look like government? And does the First Amendment have anything to do with that? And how does that all come together? And what happens when it is the government? And what happens when the government blocks you? I mean, there's so many awesome First Amendment questions that come up at the moment. And I just want to say that it's hard enough for us to understand all of those, let alone our poor students. And so I couldn't agree more. Sometimes I try to help my students walk through what might be happening or a fact pattern, but I can't always give them an answer. But I do try to at least give them some of the ideas that I have along the way so that they can go into the world. And sometimes they might even come up with a different answer than I would. But again, it comes back to giving them the tools to have a solid analysis of what they're facing. Because if we don't do it, I think in so many ways, it's going to happen from social media or other outlets that are going to help teach them maybe what they might not want, might not be needing for the long term.
Definitely. Oh my gosh, so true. Okay, so we have a couple of other really, really good ones, and I fear that we will not have enough time to get to all of these because they're so good. Okay, so a question of this moment is, there has been a great deal of discussion about it is my right to wear or not to wear a face mask in the time of COVID, which does get to your point very early on about the inherent conflict between individual rights and collective rights. So is it possible for you to discuss that a little bit and kind of tease that apart? Is that a right that people have?
Well, and let's actually even tease that apart even further, because you certainly have the right of expression, right? Free speech and free expression. And there's no question that that exists. And the liberty to not express yourself in a certain way. You can actually look, there are some fascinating documents that actually look at, in the early days of talking about free speech and free expression, whether that included clothing. That actually was discussed and debated about whether you needed to ensure that people had the right to wear a certain hat or a certain other article of clothing. The idea that that was even on the radar in any way, shape, or form is a little bit mind-blowing. But those rights are not unlimited. The First Amendment is not unlimited. And one of the most fundamental purposes of government is public health. Now, the line is not clear. The line has never been clear. The line will never be clear. This is not a bright line area, in particular because the First Amendment is so important in the view of the Supreme Court. But I will say this. I think if you look at Supreme Court decisions recently, especially regarding restrictions based on COVID and restrictions based on gatherings regarding COVID, that you can see where the court maybe views issues that arise under the First Amendment when it comes to religious gatherings and maybe different treatment of religious gatherings, maybe not. It's very hard to see some of that happen in real time. But there's no question that even in the most American of concepts, when we think about the Liberty Clause and John Stuart Mill and on liberty and the way he looked at these things, that the moment that your decisions have an impact on another person, your ability and your rights and your liberties can be curtailed in a very different way. And I just want to say that in so many different contexts, this is a great example of why that's the case. This is a perfect constitutional moment to explore these things. And it's not as easy as I have the right to wear a mask or not wear a mask. Where are you and what are you doing and how many people are you with? It's those details that I think are the distillation of rights and liberty theory. And they're the details that become the conflict that exists when it comes to rights and liberties and what we were talking about rights and liberties in conflict. And so I think it's a wonderful constitutional question. And I think we can see how it's been generally answered because generally speaking, mandates have been upheld. The public health generally is seen as very critical, even when it comes to First Amendment protections. And yet there have been moments where the Supreme Court has definitely said, you can't do something, you can't do X, you can't restrict this. And it's those nuances that lawyers get to play with and get to have fun with. I think we might have lost Emily for a moment. And I do see a question in the chat, so I can definitely answer something, so that's okay. I see somebody that's mentioning about democracy having weaknesses. And I know I mentioned that a few times. I do want to say this about that. There's really not too much of a question that there are some issues that democracy can have that are seen as weaknesses. Democracy is not necessarily the most efficient government, right? Democracy can be messy. There are questions that arise on who gets to make decisions. How does voting impact those decisions? How does the minority rights how do they get protected in a democracy? And yet, a democracy has some incredible strengths. It's a system that includes, generally speaking, far more people in decision processes and works very well in certain instances. But I want to note when it comes to those weaknesses, that there are definitely weaknesses that occur, and there are weaknesses that we can see in our own democracy when it comes to elections and voting and the way in which people have rights-based and liberty-based conflict. And so in so many ways, I want to be noticed and conscious of that, because I think we often celebrate our strengths, and we should. I'm not saying we shouldn't, but unless we look at the weaknesses in the system, how do we fix them? How do we do better? We have to at least look at them and think to ourselves, we can always be doing better. We can always be thinking about a stronger, more representative, more protective union when it comes to more and more people we are growing a democracy. And I think in so many ways, that's where my mind always goes, because we're never going to get to perfect. There is no perfect. And we should be thinking about, when it comes to those weaknesses, what can we do as a society to be civically virtuous and do what we can to address those weaknesses when they show up. And they do show up, they do exist, and it's good for us to talk about them.
Chris, I had a really good question from Katie. And this is a really just generally a fabulous question that I love. Can you talk about the importance of consent with relation to constitutional governments? So how can we in the modern day give consent to a document that has been written over 200 years ago?
In so many ways, that's a great question, Katie. And I think we give consent and assent when we consent and assent to the way that we interpret the document. And that's something that's really extraordinary. We actually do it all the time. We are constantly consenting and assenting to the document. Although I want to note this, when I say that, I want to be very conscious of the fact that while we are doing that, there are ways to alter the document. I don't think it was imagined that we wouldn't alter the document more than we have. We've only ever altered it in one particular capacity, in one particular way. That has been, we've almost used way number 2. We've never quite gotten there yet. Nobody knows what that would look like. That's what's so incredible, is nobody knows what a convention might look like. There have been state constitutional conventions, but not at the federal level. But I think that's why as much as it's from 230 years ago, we all are constantly assenting and consenting to the document. And the way in which we do so is through the elections that we participate in to have people continue to operate under the document. We, again, elect the states that have the opportunity on their own to call for a convention. We elect those individuals. So we're constantly a part of the system, and we assent and consent because we look at the document and say, from a realistic perspective, how do we interpret this today? Do we buy into that? Do we look and still see a majority rule minority rights society? And if not, how do we interact and engage to change that? I think that's what's really incredible about how this actually still operates.
It actually feeds really nicely to Kevin's question. What's your advice to teachers and students to help strengthen democracy, particularly as it seems that in some cases there's democratic backsliding all around the world?
That's such a good question. And it's amazing to see that when it comes to democratic societies, that when they are strong and when they seem weaker, and the questions that come up with multinational alliances and polarity. And I loved international relations and political science and undergrad, just because the anarchic way in which the system of government operates at a multinational level is very insightful when it comes to thinking about natural rights, natural law, legal positivism, and then legal realism. There's a lot of realism at the international level. And I think that's something that we should always be conscious of. And I think that when it comes to teaching, it's our responsibility to give as many tools and opportunities and options as we can. One of my favorite things to teach is comparative constitutional law. So comparing and contrasting our constitution with other countries. And one of the things that my students, they take so much of an interest in is how the UK has an unwritten constitution. That always takes a whole class. Explaining what that looks like always takes time. And then explaining something like South Africa, where South Africa just wrote a new constitution recently and it's 100 pages long. They just really try their best to wrap their mind around, how is that possible? And by using those comparative tools and the contrastive tools and show the number of ways in which the constitutions of the world operate and how they are just reflective, positive documents on natural laws and rights that are in each inherent society, natural rights that exist greater in humanity, and then the realism of how it looks on the ground, I think that actually in many ways is very powerful in strengthening democracy. Democracy, I think, is strengthened by knowledge. It is the knowledge and the ability to critique and discuss that is critical to our system of government. And it's important for us to do that, and to do that in a healthy way and in a productive way. And I think that's the tools that I try to give my students when I give them a comparative analysis of constitutionalism around the world.
Thank you. All right, well, I'm going to give the last question to Marie. Where do we draw the line between the government's active role in protecting positive rights and the limitation of government action to preserve liberty, AKA negative rights?
Well, in so many ways, I love that, because I am a big proponent of thinking over liberties, because liberties are more complicated sometimes than rights. Only because a right, people feel like they can point to words on a page and say, you can't do this. And I think it's a lot more nuanced, as everybody can probably tell than that. I think if anything, it's incredibly more nuanced, especially given the democratic norms and unwritten constitutions that exist and the things that we do because we've all assented and assumed that that's the things that we do in our society. So that line is a shifting line. And I don't think that line always exists in the same space. I think that line has a lot to do, and where it exists has a lot to do, and where decisions are being made in a particular government structure. I think actually just coming back to thinking about, you can look at the marriage equality movement and the questions that surrounded whether marriage was a right or it was a liberty where the government shouldn't be involved. And the debates were fast and furious. And I don't think that's a bad thing to debate and to discuss where government should be involved, where government should not be involved. But I think that line moves. I think instead of, instead of thinking of that line as a solid place, I think as society changes, and society is always changing, the way in which government is either involved or not involved, and the layers of government and the branches of government that are either involved or not involved becomes far more important. At times it's good for the courts to step in. At other times that's very undemocratic and nobody's gonna listen to what the courts say. It's good for the legislature to actually make a decision. Sometimes the federal government should be limited. It's not a bad thing that we created a limited government, and Madison and everybody else thought about that. Sometimes it's really important actually for the federal government to do something, because it should be a national response. And while we have lots of words on the page, there's so much from realism that I think informs those decisions. And I hope there's so much that we can take away from this evening that isn't confusing, but just shows the complexity of how the system really operates.
Well, Christopher, thank you so much for the presentation this evening. This has been, I've learned a lot, and I hope all of our participants have as well. And thank you so much for fielding everyone's questions. I think actually you have helpfully kicked off the preview of next week. So for everyone who has not already signed up for next week, I just want to point out that next week's question on the table is, who's in charge anyway? Because thanks to our guy, James Madison, we have this very complex interaction between local government and state government and national government in ways that is often not at all clear. So our guest next week will be Sue Leeson, former Justice of the Oregon Supreme Court, and she will help us dig into that topic a bit further and figure out, as a citizen, how can you actually get to the people who can solve the issues that you most care about? So really, really hope that you can join us all next week as we continue the conversation. So thanks everyone for joining us this evening. We will send out a recording of tonight's presentation, so you will get a link for that. And Christopher or Roy, would either of you like to send us off this evening?
Just a big thank you, Christopher, to you and your energetic approach to the Constitution. As Emily said, I've learned a lot this evening, and I hope everybody else has. And for all of you who have joined us, thank you. I follow most of you on social media, so feel free to shout out how amazing this was on Instagram. And Emily, outstanding work and a great way to cap off Madison's birthday. So thank you all, and welcome to the Constitution Initiative. Thanks, Christopher. Really enjoyed it.
Everybody.